Well, good evening, everybody, and welcome to our presentation as Northeast Private Trustees on the subject of being a trustee, all the trustee duties, and hopefully how to be a good trustee. This will be followed by a program on how to be a good boy and how to be a good girl. So in our presentations, we're going to just remind you what is a trust, what are the trustees' responsibilities, and we're going to introduce the 4 C's that help us remember these things. Who makes a good trustee? So we've got an acronym to help us with that. What types of trusts and trustees are there? Are trust accountings required, and are they hard to do? Can a trustee be liable for mistakes? Hint, yes. All right, so let's start with what is a trust? So a trust is not a legal entity. It's actually an agreement. In most cases, almost always, it's a living trust, for example, is an agreement between the creator or grantor of the trust and the trustee. Sometimes those are the same person. So you can have a handshake with yourself. On the one hand, you're the grantor of the trust. On the other hand, you're the trustee. And on the other hand, you can also have a trust created by a will. So that's a testamentary trust. And you can also have a declaration of trust. So another way of summarizing those is here. Living or inter vivos trust, that's your trust agreement. That's the vast bulk of the instruments that we would be seeing. The one under the will has to be allowed by a probate court. So if you go back to when you wrote your first will, it might have been one that said, I give my estate to my kids as long as they're at least 30 years of age. And if they're not, it's held in a trust. Well, because that trust was created under your will, it's a testamentary trust, has to be approved by the probate court to be operable. Whereas a living trust takes effect upon signing. And then finally, you can have a nominee trust, which is a declaration. That's useful for lots of little things. We won't go into it tonight too much. And you can even be a trustee by default. So the fun fact there, just that you could have a trust imposed on you if you have title mistakenly or by accident, or if you've actually stolen and have custody of an asset, you can be called a trustee. Now, most trusts that we think of, both for estate planning purposes and just in common usage, they're going to be titled revocable trust. So that title is clear in that it means that that trust can be revoked. So you can alter and amend it. You can take back assets that you put in it. You can walk away from the whole thing. You control the thing. If you're the grantor of the trust, you control the revocable trust. And as a result of that, it's also considered a grantor trust for tax purposes. The IRS is going to say that you're the taxpayer of the trust. So it's a pass-through of the trust. So that's why writing a revocable trust is so simple. And while the grantor is alive, there's no separate tax returns that are required. The revocable trust follows the Social Security number of the trust grantor. Or if you have more than one grantor, it could be either one. It could be husband or wife, for example. An irrevocable trust, on the other hand, is not revocable. It is not amendable. There are rare exceptions to that, but by and large, it's done for estate planning, asset protection, estate tax savings purposes that you have to have some specialized goal for. You have to say, well, we got a really large estate. Let's make it smaller. Let's give away assets irrevocably. So we're not going to spend a lot of time on examples of trusts. I'm going to just lay that out there as both of the basic types. And a trust can be considered a grantor trust for tax purposes, revocable or irrevocable. That might sound counterintuitive. How can you be taxed on something that you gave away irrevocably? But in fact, the irrevocable trust, I will say most of the time that the types of trusts that we draft that are irrevocable, most of the time they contain provisions that still cause the trust income to be taxable to the grantor. So an example would be you have put a rental property into the trust, then the rental income is still taxable. Even though it's irrevocable, it's still taxable back to the grantor. finally, a trust beneficiary can actually be deemed to be the grantor of the trust. And we can say that the beneficiary and the beneficiary's social security number is the number that we attach to the trust. So that has advantages in long-term trusts for beneficiaries. We may be able to avoid filing a tax return. For the trust, we can just pass all the income through to the beneficiary. So that's a little education on revocable, irrevocable, and some of the tax characteristics. What a trust is not is a legal entity or a contract. If it was a corporation, we'd have to call it that. A trust is not going to be a corporation. It's not an LLC. It is its own thing. It's a unique fiduciary relationship. It's an arrangement. The IRS is going to tax a trust as though it's an entity. So they have their own tax system for trusts at the IRS. But that doesn't make it an entity. It's still just an agreement, a declaration, or a testamentary disposition like we outlined. The trust doesn't actually own assets or hold title to the assets. The trustee does. And it's often mistaken, I guess, is the way that I would summarize that. It's not an entity. All right, the trustee is the person or entity. It could be a corporate trustee, an entity that has custody and responsibility to carry out the terms of the trust. That's the trustee. So if you're a trustee, you have all of these duties, or you're going to have all of these duties. Again, the trustee is not a president, CEO, or an officer. It's more like just having authority to carry out decisions. Now, trusts have been around a long time. If you're looking for the oldest written evidence of that, you could go to the scriptures, and you'd even see evidence of that there. Turns out George Washington served as a trustee for his wife Martha's kids from her first marriage. It seems like most husbands died before age 40 back then. In this case, George Washington was the beneficiary of not only Martha, but her two kids, and inherited through her, a lot of Custis property. But anyway, he was a trustee for them, and he had to watch out for them. He was able to charge a fee to do that, it turns out, as well. A modest one. George Washington was certainly a man of propriety. In 19th century Boston, a very important case that was the basis of what we know as the prudent investor rule came out of Harvard College versus Amory. And essentially, the story there was that Amory was the trustee, and he decided to invest in some manufacturing companies in Boston. And he didn't diversify much. He kind of stayed with one company. Guess what? The company didn't do well. They failed, and the trust lost a lot of money. Harvard College was the beneficiary of that trust, so they sued Mr. Amory, and they said, you should be personally liable for losing all of that money. But our Supreme Court of the state said, nah, that's not really how it's going to work. Trustees just have to operate in good faith, use their reasonable discretion of what a prudent investor, what a reasonable investor would do under the circumstances. And in order to get a good return on money and grow the capital of the trust, sometimes you have to invest in corporations. You can't just invest in certificates of deposit or bonds that don't grow in their principles. That was a very important case. Boston is very central to the emergence of trust law. Nathaniel Borchers was perhaps the earliest professional trustee. As you can see from his photo, he was also the early model for Count Dracula. And my biggest fear in being a trustee for very long is that someday I'm going to look like him. We're not alone here in the UK. A lot of the Dickens novels deal with trustees handling assets. The one that most people have read, Great Expectations, Pip was the beneficiary of a trust created by this convict who must have stolen money and given it to a lawyer to look after. So Mr. Jaggers was the trustee in that case. Now, in general, a trustee is a fiduciary. So you see that term thrown around a lot in today's financial parlance. But a trustee is somebody who has a high level of duty. They have to take extraordinarily good care of assets. There are many other ways in which the term fiduciary is used. For example, lawyers are considered fiduciaries for their client. So we have to have their interests first. Companies like Dante's here is a registered investment advisory firm. They have to have the interests of their clients come first. But you can also be a fiduciary if you're on a corporate or nonprofit board. But for a trustee, their job and their only job is to be a fiduciary. They have to put the interests of their beneficiaries first. Who can be a trustee? Well, to me, there's a little buildup to this story. So look, there's a lot of things that you need to be licensed for. You need to have some credential. For example, we don't send our kids on a school bus without some training by the bus drivers. We don't just let anyone prepare or file our income tax returns. Not just anybody can work on our car. They have to have certifications. And we don't take tankers or expensive yachts into a harbor without a harbor pilot or fly airplanes without an airline pilot. Not just anybody can be you get the idea. Yeah, there's a lot of professions and jobs where you have to have training. Who can be a trustee? The fact is, anybody can be a trustee, which surprises me a little bit because that means we're really letting just anybody. I mean, they might be people that we intuitively trust. If we're a parent, we might think our children are trustworthy. Last we checked, but by the time they start handling the estate and the trust, can turn out really quite different, it turns out. But they're the ones that are also making legal judgments, interpreting beneficiaries' needs, and providing accountings. Quite a responsibility, and yet the law says anybody can be a trustee. The tradition in Boston, the Boston Trustee, and that's the name of that book that was on the cover a few slides back. Here we have a long tradition of lawyers being trustees, banks emerged as trustees. Interestingly, hospital nonprofit corporations were trustees. So you had the Massachusetts General Hospital Trust, you had the Rhode Island Hospital Trust. There's a lot of lawyers that are serving as trustees just in a one-off situation. They've got a client who did an estate plan with them, or maybe they're not even an estate planning lawyer. Maybe they could be the corporate lawyer or a trial lawyer, but their clients trust them and they say, will you be my trustee? And so it's a one-off situation where they make their way through being a trustee, or they learn the job on the job. There's also a statutory corporate trustee in this state and in several other states, but it's kind of rare. In this case, Massachusetts allows our company, for example, Northeast Private Trustees, to serve as a fiduciary without being a bank. We are not regulated, overseen by the Banking Commission. So there are professionals in the room who are trustees. So why even be a trustee? This is about to be a lot of responsibility. You've heard there can be some liability. For some estate planning lawyers, you could think of it as the culmination of your career. And what better way to serve your client than to say, I planned their estate, I've helped them through the years, and now I'm going to help their family. I'm going to be their trustee. I'm going to be their executor. It can be interesting. You like helping people. You like using your expertise. You can do it later and longer. You can do it, well into your traditional retirement years. Make an impact. Somebody has to do it. Why not me? It's an adventure. Each case will be different. I don't know. If you're a professional, think about it. Maybe it's not a bad thing to try out. There's also an aspect of sort of this lawyer trustee hero complex where, we've got to do the ultimate good for our client. Some people seem to pull this off better than others. You really need a whole different set of competencies. in doing this, and going from the classroom where you're an estate planner to go into the field and actually do the work. One example of that happening was Professor Jones, who turned into Indiana. And what will I turn into is my question. Somehow I hope to be that heroic trustee. All right, so what are these four C's that we were talking about of our duty? So I call them custody, care, collaboration, and compliance. The first of these, custody. So the first job is to hold on to the assets. So that might seem pretty obvious, but there's a particular way we need to do that. We need to do it very carefully. We need to do it with a fiduciary duty. So we should be taking inventory of all the assets, tracking carefully what's there. In a state that you're familiar with, hopefully you already know what those assets are. Clients of our law firm already have the benefit of us tracking very carefully all of their assets. So by the time they get into our trust company, we already have a great listing. We call that the Asset Trust Organizer. And that can be the inventory to start off the estate. And I'm sure Mackenzie and Emma are thinking, I wish it was always that easy. So short-term responsibilities may be to sell and just turn the assets into cash, turn the money over to the beneficiaries, and other long-term, however, it requires that the trustee be a good steward for a good length of time in this custody relationship. We should, in this relationship, work with banks and fiduciary advisors that we are comfortable with, that we trust. If we're doing a lot of this type of work, we want to have a good long-term working relationship with such institutions. However, not all registered investment advisory firms are familiar with trusts. So just because people have other credentials like certified financial advisors and CFAs and so forth, that doesn't necessarily mean they're that familiar with how to run a trust and what are the particular rules there. But RIAs are who we must choose to work with because they are required to put their customers' interests first. And remember, that's our duty as a trustee. The fiduciary is to make sure that the beneficiaries' interests are coming first. So that's why we have to choose financial advice the same way. We should know what advisors are going to be charging. Is it percentage? Are there other fees involved, transactional fees, et cetera? Let's move on to care. Now, we could spend a whole evening on the care topic. So I'm going to do the best I can in 4, 5, 6 slides here. So the trust instrument is the first place you look for how do I take care of this beneficiary or beneficiaries. So I like to say that trust instrument directs how to take care of the beneficiaries, sort of. There's so much more we don't know. So reading between the lines and reading the law will be helpful. If we knew what the grantor was thinking, sometimes the grantors or creators, remember, of the trust, even they are not clear about necessarily what they're intending. And furthermore, circumstances can change by the time people have died. You wrote your trust when your beneficiaries were only 40 years old, and when you die, they're 65 years old. They may be in very different circumstances. So there's a lot of reading between the lines. Was the trust meant to be liberal, moderate, or conservative in its distributions? If a trust is conservative, it's probably going to be building for growth, and it's probably going to last beyond the lifetime of the current beneficiaries. It's probably going to be there for the next generation. There's a place for that, definitely a place for that approach. The liberal approach, on the other hand, you might think of as, if that word appears in your document, it's probably meant to be consumed, or it's likely that the trust will get consumed because the beneficiaries will point to that word and they'll say, my mother said, be liberal. And other words that'll be there might be happiness of the beneficiary and so forth. And what beneficiary isn't happier with more money? So However, that said, we may have to still say, well, look, you're only 25. If I give you all the money by the time you're 30, there's nothing left, and you don't even have a job. As trustees, we have to be very circumspect, and we also have to be as objective as possible. It's not always a good spot to be in if you're a family member in this position, and very often you seek the advice of attorneys, or you even turn the trust over to an independent trustee because you don't want to be in that hot seat. Now, a common standard that's going to be put in the trust for care is HEMS, or health, education, maintenance, and support. This is an example of an objective guide or ascertainable standard. The reason that this is so important is that using a HEMS standard for distribution, it is possible for the beneficiary to be the trustee. Yes, you heard me right. The beneficiary can be the trustee. So if a parent leaves a trust for a child, the child can be the trustee of their trust. If they have a HEMS standard, if they don't have some standard to govern their distributions, then they basically have a blank check, and there's really no trust. They can write themselves money. They can dissolve the trust. They can write themselves checks out of the trust and give them all the money that they want. So an ascertainable standard means that the beneficiary has to be governed by something that's objective and measurable, focusing on these terms: health, education, maintenance, support. Now, health and education are probably the easiest ones, aren't they? Because if you have an uninsured medical bill and you don't have enough to pay that bill, then you can pay it out of the trust. We have one of those trusts that we're serving on right now that will go a maximum of 20 years. The grantors left it specifically for the health of their nieces and nephews. And every year we ask the beneficiaries to submit their medical bills. So it's clear that what we have to pay out for medical purposes, anything that's not covered by their insurance up to a cap. Education, likewise. Now, maybe we're trying to decide between vocational, private college, public college, but still, if somebody needs education in order to they're a young adult and they want college education, that's what's expected, then that's easy to pay for. That could include graduate school, it could include study abroad. So that can be quite broadly interpreted. So the real tough ones are, what is maintenance and support? So there is some guidance on this that we'll find. For one thing, there is some guidance in the Internal Revenue Code and regulations. So the regulations themselves provide for reasonable comfort, is a term that's recognized. And the reason it's in the tax code is so that if a trustee has these powers to give themselves reasonable comfort, then the Internal Revenue Code says that that's objective enough that the contents of the trust are not included in the trustee's estate. Okay, I might be getting a little ahead of some of you, but that's a desirable thing. In other words, if you're the beneficiary of a trust, you don't necessarily want the whole trust to be included in your estate. You'd rather it be included in the next generation's estate, for example. So having the ability to tell a trustee you can pay yourself for your reasonable comfort is enough to keep it from being taxed or let's say overtaxed. Maintenance and health and reasonable comfort. Reasonable comfort also has been interpreted in the next bullet: accustomed manner of living. That's a common measure. So I've often wondered, well, what about a college student who comes from a wealthy family, but while they're in college, they have no income? At least when I was in college, I ate garbanzo beans and hot dogs. Well, that was law school, actually, because I was truly on my own. But if that was the accustomed standard of living, no, thank you. But I think what it means is sort of, what what would you expect? What would go along with your college education, your law school education, et cetera? Or what was your family accustomed to? But it also, I think, is enough to allow us to bring people of lesser means up to a reasonable standard of living. So somebody who didn't have much could be easily brought into the middle class, I guess is the way to put that. So it could be a custom manner of living, or we could bring them into more reasonable comfort. Again, education, medical, dental, unreimbursed expenses there, hospital, nursing, expenses of invalidism, that's literally in the code. Sometimes the HEM standard is thought to be in consideration of other income and resources. This is a very important distinction. So if you have a trust that says, take care of the support and maintenance of the beneficiary, and it says nothing else, the presumption is going to be that the trustee has discretion, whether they look at their other resources and income, or they don't. In other words, the trustee can say, well, you've already got plenty of money to pay for your housing and your health needs and your food and your clothing. You already have plenty. The trust isn't really going to give you anything because that's my discretion. I'm using my discretion. You don't need any help with your maintenance and support. So the wording of the trust is going to be very important. This case that I cite here, the Holyoke Wilson case, that there was unequivocal intention that living expenses are to be borne exclusively by the trust income and principal, because the trustee was authorized to use the principal for comfort, maintenance, and support. And I think there the court leaned into saying it's okay for the trustee to go ahead and provide for all of those needs. But on the other hand, in the Woodbury case that's next, there was means testing that was asked for. So if there's such words as when in need or if necessary, or I'm adding this, it wasn't in Woodbury, but taking into account other resources available. So you can see when in need means, well, I'm not going to give you anything unless you prove to me that you need money. That would be an example of where we would use the discretion much more cautiously. All right, now, if you don't have an ascertainable standard in the trust, then what do you have? Usually you have discretion. It may be wide discretion, or it could be narrow. So some of the adjectives that would describe discretion would be wide, unfettered, absolute. If you have absolute and unreviewable, or total decision-making, total and absolute, anything like that, it's going to mean that the trustee, unless they're operating in bad faith, I mean, they're really trying to put it to the beneficiary, they've got a grudge against them or something, they're going to be upheld in court for withholding a benefit to the beneficiary. They can say it's in my discretion, I'm not giving you anything. A case from last decade, Borchers v. Kraft, also talked about using discretion to take all of the assets out of the trust. The entire trust was emptied and put into a new trust. That's known as a decanting, and that's because there was total decision making authority there. If there had been a HEM standard, I don't think that would have happened. I don't think you could have taken all the assets out of one trust and put them in another, presumably better trust. That was the idea. Jonathan Kraft wanted a better trust. All right, if using wide discretion, the trustee always has to act in good faith, and this is part of our black letter law now. Upon acceptance of a trusteeship, the trustee shall administer the trust in good faith, in accordance with its terms and purposes and the interests of the beneficiaries, and in accordance with the trust code. So you got to look at the trust, its terms, got to operate in good faith. Good faith is not really that clearly defined, and there's some controversy over whether that's really more of a contract standard. But the Mass clearly has ruled in some fairly recent cases that failing to consider the interests of all the beneficiaries would be a breach of duty of good faith. So if you have more than one current beneficiary, or if you have beneficiaries that are alive today, but you know there's supposed to be money left over for beneficiaries later, and you're not thinking about the ones who come later, you may be breaching a duty to those future beneficiaries, also known as the remainder beneficiaries. That was the case in the Fournier situation, where the trustee wanted to be able to give out money to, in fact, it was proposed that the trustee give all the money to the nursing home charity that was taking care of the grantor of the trust. And the court ruled that, well, if you do that, there's no money left over for the remainder beneficiaries. So they thought that would be a breach of duty, the duty of good faith. So I don't go through all of these examples, but you get the idea that there's a high level of scrutiny to what we do. Are we doing it with proper discretion? And one of the cases that we rely on a lot, the Leviton case, is one where we point to that case as evidence that you can use a trust to prevent beneficiaries from losing the contents of the trust in a divorce. So you've got a beneficiary who's a beneficiary of the trust going through a divorce. If the trustee has wide discretion, they can turn off the benefit. But other cases have also said that you may be able to turn off the benefit, but later on they're going to be able to get the benefit anyway. So that's not going to be as good. And we're going to say that eventually the beneficiary is allowed to get it. So in divorce, and that's the Jones case, the Jones case says eventually they're going to get the money, even if you could withhold it temporarily. So there's a lot to interpret in both the trusts and in the cases regarding the trusts that have gone through litigation. And there's no such thing as standard trust language. We use trust language that says one thing. Another firm will use language that says something quite different. I had a trust that used the term that we're supposed to use the money for the beneficiary's advancement. First time I'd ever seen that. The trust was drafted in the Bahamas, and I couldn't find any evidence of what that meant in the Bahamas. I was tempted to go there and see if I could find any evidence. Specific examples from regulations of non-ascertainable discretionary standards. So again, just driving the point home, such broad terms as comfort, welfare, best interests, happiness, needs, advancement, well-being, reasonable luxury, for any purpose, for an emergency, or to enable the beneficiary to make gifts. These are all examples of too broad to be narrowly understood or ascertained. And that's good if you're trying to find some basis for your decision as a trustee to give the beneficiary money. You got a lot of discretion. It's bad if you're the trustee and you're also a beneficiary, because that probably means you own the trust and it can be taken from you by a creditor or in a divorce, or the government's going to tax you on it. All right, the next C is collaboration. In other words, cooperation, good communication. So we need to set the tone as a trustee for the level of cooperation and collaboration. This means inviting conversation, discussion. This has to be two-way. Not all beneficiaries are cooperative. They don't all sign up for our meetings once a year. Surprisingly, because trustees are being paid, so why wouldn't you want to at least make them work for their money? They have to open up. They have to tell us about their needs. If they don't, then either they'll get nothing or they'll get some minimal amount, depending, again, how we read the trust. I think goal setting is overlooked. For beneficiaries that are going to be receiving benefit from a trust for a long period of time, we need to know what are their wishes, goals for higher education, or maybe the trust has the ability to pay off their mortgage or help them to save for retirement, or they don't feel like they can afford to have a financial plan, or an estate plan, and so the trust will pay their legal or financial planning fees. So that the trustee can really find out a lot about the beneficiaries with these conversations if they open up, and it can be collaborative. It can be not, you know, a source of resentment for beneficiaries who can't get the trustee's attention, can't communicate. The trustee only sees things one way. So let's get the cooperation and collaboration going. Trustees also need to collaborate with other professionals. So we talked about financial professionals, but also lawyers, tax advisors, CPAs, maybe tax advisors. Sometimes they're just preparing tax returns. They're flattered if you ask them to help them also understand what planning they might do to help with to save taxes. Bookkeepers, property managers, sometimes, as happened to me once, I had a trust that I was trustee of, and it said, give all my money to charities that I like. So I had, you know, like I'd been to their house a few times. The Catholic TV was always on in the background. So I thought, well, they're probably Catholic. And they had two little Bichon Frise dogs. So I said, oh, they must like dogs. So I'll give all the money to the Catholic Church and dogs. I didn't quite do that. I hired a philanthropy advisor who found some wonderful charities, including Mercy Ships. And yes, there were some direct Catholic charities in there. And we used money to support the service dogs, Needs Service Dogs, a great organization training dogs. And a wonderful experience. I was joking. I didn't just flippantly give money out to any old charity. And we paid $15,000 for the philanthropy advisors to tell us how to do that, but it was money very, very well spent. And we had some very happy charities. If you're talking to beneficiaries about their own needs, you may need to talk to some of their people as well, whether it's their social worker or maybe some medical people. I even wrote parole officer in there. Because yeah, that can happen too. Now, compliance is maybe dull, but very necessary. So it starts with providing notice to the beneficiaries in the beginning when you take office. So our law actually provides that you got to give notice to the beneficiary that you are the trustee and how to find you. So your address, telephone number, email. When you take office, you have to do that within 30 days. You should provide a copy of the trust document. The statute says keep the beneficiaries reasonably informed. So I don't think there's any way to be reasonably informed unless you have a copy of the trust instrument. So that makes sense. Besides which, if you give them a copy, then that gives you a defense. If you're the trustee, it gives you a defense that later on when they say, well, I didn't know that, you can point to the fact that on December 12th, I gave you a copy of the trust. I have the cover letter right here. Naturally, there's going to be other things for compliance. So tax filings, some tax planning, certain requirements that appear in the trust documents themselves for trust shares that have to be created, particular distributions. The trust might be very specific, might give beneficiaries right of first refusal to buy a property out of the estate. I was talking about one of those today. Out of 4 kids, only one of them is going to want to have the vacation house. So should we give him an option to purchase it from the estate or give him a right of first refusal to buy it if it goes on the market? If you don't read every paragraph of the trust, you might miss some of these things. Then there's the law of the state where the trust needs to be interpreted. That's usually the law of the state where the grantor was living and where the trust was drafted. But then there can also be separate law for the state where the trust is being administered. So our law says things like you give notice within 30 days. That's not necessarily the law of the state where the trust came from, but if it's being administered here, we have to follow that law. And then finally, accounting. Accounting is the biggest pain of it all, I think. Just trying to show where every dime came in and went out. Absolutely necessary. What better way to prove that you're faithful in your performance of your duties than to be able to show what happened with the money. So what form will an accounting take? Is there any guidance in the trust? A lot of our trusts say it's a sufficient accounting if you give beneficiaries a copy of the tax returns and financial statements from institutions. So you could just say, here you go. It's May 1st, taxes have been filed. Here's your copy. Here's all the statements from December, at the end of last year. Voila, have at it. If you have any questions, let us know. That's not the most friendly way to do it, but if you have well-informed, well-educated financially anyway, beneficiaries, that might be all they need. And that's going to save expense of the back office having to prepare itemized accountings. Now, that's not to say it wouldn't benefit you to still do an accounting, because you may have to someday prove what you started with and where the money went in the meantime. So I think it's better to start with the presumption that you're going to provide an inventory of assets in the beginning, and then you're going to show at the very least what the expenses were and the ending balance of the accounts, whether you do that every year, preferably, or periodically. So let me repeat that. You're going to start with the beginning inventory. What was everything worth at the date that the trust started, with the date you took over as trustee? If you took over from another trustee, you do your own inventory as of that time when you take over. And again, at the very least, what were all the expenses? That includes legal fees and trustee fees, financial fees, distributions, taxes paid, other professional fees that are paid. So people know where the money went, and then what the ending balance was. If you really take that to an extreme, you'd also show every single sale. Was there a gain? Was there a loss? And accountings can become very, very long with all of that itemization. I don't think that's what's called for in most cases, because I don't think beneficiaries gain much from that information. They're mostly interested in what was it worth then, what's it worth now, and where did the rest of it go that isn't obvious here. Especially in a down year, they want to know what happened. Next. Oh, you can also set up trusts so that the beneficiaries are getting the statements every time you are. You can set it up so that the institution is sending that out quarterly to them, so they're keeping up with you. So detailed principal and income accounting is a real nuisance. I'm not going to get into that right now. Using spreadsheets to track cash, that just makes sense. It's easy enough to do. Maybe you can do a download from the bank if the bank is able to do that with your software, with QuickBooks or whatever you're using. We're also talking about providing a copy of the IPS. I skipped over that slide, I guess, a little briefly earlier, but the IPS is the investment policy statement. So you should have a statement that is your guide for how the assets of the trust are being invested. If you have cash that is in on January 1st, and you're going to settle up the whole estate by distributing cash by next January 1st, your only investment policy statement is to keep the cash in the bank where it's safe and it's FDIC insured. You probably would be forgiven if you didn't write that down as an investment policy. But as soon as you start talking about, we want this money to be there for beneficiaries in 10 years when they go to college, or to be there for their retirement, we need to have a plan that will show how we should be invested. You know, is it how much is in the stock market versus how much is in income producing assets. So that becomes your investment policy statement. That should be provided to the beneficiaries so they know what your philosophy is. It's also another self-defense. If they know what the philosophy was and they're not complaining about that, then that's another reason why they they shouldn't succeed in blaming you later when things go poorly because they knew about the policy. Not a mandatory thing, but I think it's a reasonable bit of information for many beneficiaries to receive. Perhaps as accountings are done, also stating the credentials of the advisors that are part of the team. Trustee fees. So one of my friends, Josh Yeager, is a lawyer in California, and he does a lot of advising of trustees. And one of his things is he writes these cartoons on a legal pad. And you know, the trust settlor says trustee compensation should be reasonable. Which is the law of most states. Well, you get a reasonable fee, whatever that is. And the trustee says, so how much should I get paid? And the beneficiary says, zip, zilch, nada. Beneficiaries have no clue half the time, if not most of the time, really what goes into managing a trust. The usual choices are hourly, flat amounts, or percentages. Our particular procedure at Northeast Private Trustees is a percentage of the trust estate when we are serving in all of the capacities as trustee, doing all of the duties. So on the first $1 million, for example, then it would be 0.9%. So that would be $9,000 for the decimally impaired. On the next million, 75 basis points and down from there. And that's the way these things are always done. The larger the amount, the lower percentage fee would be. Now that would be typical, a little bit lower than the standard market that you'd find around here and probably anywhere in the country. Usually they'd start at 1.25% for trustee fees. And naturally, that's among the things that need to be disclosed as a matter of compliance. It's also a tax-deductible expense to the trust. A very simple example of a basic accounting would be balances of assets from the prior year's accounting. This is actually, no, I'm sorry, assets and income for the year, expenses and distributions, and a balance. I mean, a lot of times that's all beneficiaries want to know. What do we have? What did you spend? And what's the final balance? The next year starting balance is the same as the prior year's ending balance. And then you get new expenses for the next year, leaving another balance. So sometimes accountings can be that simple. Next is an example of a high level of detail. So here's a little snippet of one that shows, literally how many pennies of interest was paid out on various accounts. If you have to do an accounting that's supervised by the probate court, then they want you to do schedules A through F with this principal and income accounting, which is a lot of fun. All right, worth noting. So if you don't do these things, these 4 C's, you risk being removed as a trustee, or you could be sued personally. If you win the lawsuit, you can take your fees from the trust. If you lose the lawsuit, you're probably going to have to pay all of the fees for defending yourself personally. You can be surcharged, which just basically means you can be charged back for any fees that you took already. And if you're a professional, you could be disbarred or lose your license. And this can happen for failing to follow the trust, failing to communicate, to account, to manage. In other words, to do all the things that we just talked about. So sort of summing up those duties and how they manifest themselves, a trustee is trustworthy, is reliable, is understanding, compassionate, is a good steward following after the assets, is tenacious in all the details and pursuing things diligently, is ethical, And I don't think you can do this, at least not in any volume, without having good experience behind you already. In other words, you wouldn't just get out of undergraduate school as a psych major and set yourself up to be a trustee. You best get some experience first. Common issues for our trustees are misinterpreting trust terms, failing to understand what the documents say, making poor investment choices. Now, you're not going to be liable if the stock market goes down and you're in an index fund and the RIA told you that was a good investment to be in. You're not going to be liable for that. Beneficiaries might think you could have done better. Everybody thinks somebody could do better if they timed the market perfectly, right? Why didn't you sell when it was high and buy when it was low? You're not gonna be liable for those kinds of losses, but if you do just literally the wrong thing, violating the duty of a prudent investment. So I wouldn't put your money, for example, in like Ukraine or Israel right now. Neglecting record keeping, tracking assets. Oh, what a problem that is, because then you have to go back and forensically reconstruct years of accounting. I've seen huge bills generated from having to reconstruct that. A few more slides, and I think we'll finish up this part of our talk and go to questions. By the way, again, reminding you, if you have a question, please jot it into the chat so we can pick up on those in a few minutes. Failing to communicate, making improper distributions. One of the trusts I took over a few years ago, I was appointed by the Middlesex Probate Court, where two sisters were appointed as the trustees. The third sister was under a disability, and I think she might have done a better job than the other two. But one of them said, "Oh, well, I'm going to just start distributing money," and she gave money to all of the grandkids. Her father was the last to live, and just started giving money to the grandkids. Well, it's true that the grandkids were beneficiaries of the trust, but not in the amounts that she gave out. She gave herself money. She gave one sister money, didn't give money to the other sister. She was removed. She was surcharged, but she was judgment proof. There was no way to get money back from her. Just an awful, awful situation. And you ask yourself, how could the father put such people in charge? He didn't know that they were not going to perform. One behind his back, they were going to do things their own way. So I was brought in as a replacement trustee to straighten all that out, and the accounting was a nightmare. Failing to file tax returns, failing to comply with court orders, breaches of fiduciary, any action that violates the trustee's duty to the beneficiaries, like self-dealing. I have this story that I've told a few people, which was that one of the first estates that I was ever appointed a trustee on was a woman who passed away with no family. Her husband had already died. She didn't have any kids. The family was distant. And although they were told to come and pick through the belongings, none of them did. And I saw in amongst her belongings, she had one piece of something that had belonged to her husband. It was called a valet. Does anybody know what a valet is? It's what you hang your jacket on. If you don't hang it up in the closet, you have a valet. Okay, so I thought that's really neat. I wonder what a valet costs. So I don't know how I researched it, but I thought it was worth $75 or whatever it was. And I put $75 into the estate, not thinking that I was breaking any rules, but I totally was. And to this day, that reminds me, it kind of haunts me every time I see my valet where I hang my jacket. And one of our new employees is a wood burner. She has a wood burning kit, and so she can inscribe on things. in her burning tools, and I'm going to ask her to inscribe hubris on there, because I guess I thought I knew better than anybody else. But it turns out, I mean, I didn't know that rule. It's too bad I didn't. And the estate got $75 instead of it going into the dumpster. So you think, well, isn't that good? The estate got money. You're not supposed to do that. You're not supposed to do any self-dealing. It's a violation of your duty of loyalty to the estate. It doesn't make sense, but that's the rule. So you could be surcharged for that. I think I'm safe at this point. That was about 30 years ago, 35. So finally, you're a trustee. What do you do first? So basically, get organized. Know the trust terms, figure out how you're going to account, get yourself set up. If you had any ideas about buying property from the estate, don't do that. If you happen to be friendly with the beneficiary or a lawyer for the beneficiary, and at the same time you're trying to be their trustee, telling them no on the one hand, I can't give you that money. Meanwhile, as a lawyer, you're thinking, I want to do the best for my client. I want to give them money. That's not a good position to be in. There's probably going to have to disqualify yourself from being a trustee under those circumstances. So what we're not going to have time to do is do anything about setting yourself up as a professional trustee. And all the professional trustees that are in this room already have the benefit of this level of organization. So we'll save that for another time. So at this point, actually, I'm going to skip to the end and just tell you what we have in store for some future presentations. And our next presentation is coming up on March 6th. Which trust do you trust? Irrevocable or revocable trust. So this will be an interesting education on the differences between those two things. We're going to have legacy and libations, something to do with wine, I think. And a little bit of law at the same time with Deb Hedges, Mark having done the first one. And then following that, Mackenzie Hager will be starring in the role of telling you how to avoid problems in settling your parents' estate. So if you want to take a picture of that, go ahead, or a picture of your screen. You will also find this in the chat. I believe we've copied all that material in there. There's also my email and our phone number if you have any questions there. Now, I need to get over to our chat. Okay, let's see if there's any questions for us at the present time. Are there any questions in the room? Not having done this particular presentation before, it's hard to know whether you're giving too much information, not enough, high level, detail level. What do you do? But Sue.
Yeah, I'll ask a question. What's the situation when you're the trustee and the sole beneficiary? All the accounting things that you're talking about. I mean, obviously you still have to file taxes and do all that stuff, but you're really only accountable to yourself, I assume. Like you can bypass a lot of what you talked about, I assume.
Yes. So the question is, what do you do when you're both the trustee and the beneficiary, and can you buy?
The only beneficiary.
Is in fact the only beneficiary. So it will depend somewhat on the wording of the trust, of course. So for example, if it said you're only supposed to get the income produced by the trust every year, then you can't pay yourself principal. So you have to pay yourself just the interest and the dividends or rents and that kind of thing. If the trust happened to say that although you're the only current beneficiary, that there's some objective to try to make sure there's money left to pass to the remaindermen, the people who come after you, like your children, if you had any, for example. So it would depend what the trust says, but the trust also may say that it's okay to give an accounting only to the income beneficiaries. Well, you're the only income beneficiary and you're also the trustee, so you're not going to bother with any of that accounting stuff. Now, what I have seen is that sometimes the beneficiary who's looking out for things competently during their lifetime, they may pass away with no or very few records for the next beneficiaries to say, what happened? When grandpa died, we thought the trust was worth millions. And now that mom has died, there's only 300,000 left. What the heck happened? If you, I guess, want to leave them in the dark, the next trustee really just takes over at that point, and you don't really have to give any further accounting to those folks. The trust code in this state says that you have to provide information to qualified beneficiaries, and you don't become a qualified beneficiary until the moment that you're entitled to that inheritance, the next level of inheritance. That was clarified by a case called Colecchia in 2021. And that case was really helpful to convince us that, otherwise you'd have to be giving accountings to people that may not get money for decades. So the short answer is that you can simplify things. If you want to feel like you're leaving people with some sense of what happened, you might keep a running balance, at least of what the account balances were, say January 1 of each year. And if you left the last year's worth of records, that to me would be sufficient. You'd probably would be in a good, you'd be remembered fondly at that point. Okay, we have a question in the chat. This is a scenario presented. I am the trustee and my father is the grantor. I am also the only beneficiary. We are soon selling his home so that he can move in with my husband and I. We will need to do a large home renovation and to enable this. Can we utilize a portion of the upcoming proceeds from the sale of the home, which is in an irrevocable trust? So the money's in an irrevocable trust, meaning that dad really can't get the money. The type of irrevocable trust this is, I'm quite sure, is one that does allow the distribution of the principal of the trust to the daughter who is the beneficiary. So dad has the right to the income from the trust, the right to live in his home. Now the home is going to be sold, it's turned into money. Now the trust has all this money in it. Can the daughter use that money in the trust to improve the home where her father is going to live? And so there's going to be a couple of possible outcomes for that family. It could be that literally the money is taken out of the trust, given to her, and she can do whatever she wants with it. She can tell her father she's going to improve the house and he can move in, but she, in fact, takes off for Las Vegas. But knowing this beneficiary, I doubt she'll do that. The alternative would be she could have the trust become a co-investor in the house with her. So the trust would own a portion of the house equal to that investment. That could have some advantages. I'd have to think about that a little bit. Where she's the only beneficiary, I don't see much harm probably in telling her that she could just take the money and invest it into the house. If she had other siblings, it might be better if the trust remained an investor in the house. Would probably be a better solution. All right, well, no need to belabor it. We're already beyond, we're at 10 minutes after being here for an hour. So and all of you Zoomers out there, thank you for joining us. And if you have any further questions, be sure to be in touch with us. So thanks again for being with us tonight.
Yay.